A lawsuit filed by the opponents of same-sex marriage faces an uphill battle. The complaint from New Yorkers for Constitutional Freedom focuses on how New York's law was passed. The suit argues that the closed-door conferences held by the Senate Republicans to debate the bill, championed by Governor Cuomo, as you'll recall, violated the state's open meetings law. It also takes issue with the limited floor debate on the night that the bill was passed, which is a complaint that has been echoed even by senators who voted yes. My next guest is an expert on government transparency. He is Robert Freeman. He is the executive director of the Committee on Open Government, and he is joining me to discuss this lawsuit. It's lovely to see you, actually.
The pleasure is mine.
You're a man in demand. We tried to get you, and you were busy. So here you are.
Speaking to reporters in New York City.
Yes, I'm very pleased. This lawsuit, I actually find it a little bizarre that they challenged the process and not the content, because they mostly take issue with the content, which seems to me, and I'm not a lawyer, to signal that they think that the content is sound legally. Somebody said to them, the content is sound, this is your only avenue. I mean, but the avenue is pretty rocky.
I think that your analysis is correct. They're not suggesting that the law is unconstitutional. Right. They're suggesting that the open meetings law was violated. I question, however, since I read their papers, whether they actually looked at the open meetings law. I don't remember when you arrived, but there's a history here, and if you want to know about it, I'll be happy to describe it.
Yes, actually, it entails Fred Dicker.
Yes, it does, as a matter of fact. Well,
I love
the open meetings law went into effect in 1977, and basically it says that meetings of public bodies like the Senate, the Assembly, the City Council, the Town Board have to be held open to the public,
right,
with certain exceptions. There are 3 exemptions that appear at the end of the law. If an exemption applies, the open meetings law doesn't. It's just as though the law doesn't exist.
Okay, wait, let's see if I can do this.
Okay.
One of them has to do with if you're going to discuss employees.
No.
No?
No.
I think if you go into executive session and all of that.
Listen to me.
I'm sorry.
There's a distinction between an executive session,
right,
which is defined to mean a portion of an open meeting,
okay,
and the law lists the 8 grounds for entry into executive session, and an exemption. If an exemption applies, the open meetings law doesn't at all. It's just as though the law doesn't exist.
Okay, I get
There's no notice requirement, etc.
Okay.
One of the exemptions from day one has involved political committees, conferences, and caucuses. So the question from day one was, what does that mean? And we, the Committee on Open Government, offered opinions. 5 courts agreed with us. And in essence, what we suggested was that if a majority of a legislative body gets together to discuss public business, that's a meeting covered by the open meetings law. On the other hand, if they're discussing political party business, that would trigger the application of the exemption. The open meetings law would not apply.
Ah, okay.
And that was the law, it seems, until 1985, when the reporter that you mentioned,
Mr. Dicker.
Yes, as I understand the situation, wrote to the Speaker, which then as now had a significant majority of Democrats, and pretty much said, unless you open your caucuses within a couple of weeks, we're going to bring a lawsuit. Well, the state legislature, in my opinion, in uncharacteristic fashion, acted practically like that in changing the law. And since 1985, the law has said that the members of a particular political party who serve in the Senate or the Assembly or the legislative body of a county, city, town, or village can meet in private in a closed caucus to discuss anything, including matters of public business,
okay,
and they can invite staff or guests.
Okay. I know, well, they could invite reporters if they so chose.
Oh, if they so chose.
And actually, it should be noted that when they discussed same-sex marriage, they actually had a number of people in there to talk to them, including Mayor Bloomberg, who is an issue in this particular lawsuit because, of course, he then subsequently donated a lot of money to folks who jumped over Republicans and voted yes. He also then donated money to Republicans who were leading the charge for voting no, which would include someone like Marty Golden. So there's really no rhyme or reason to it. But they also had Bishop DiMarzio from Brooklyn in there. I mean, they had people who were representing the no side. So they really did have guests in who represented both sides. I mean,
again, assuming that this was the Republican conference that invited in the guests,
they did.
The open meetings law simply would not have applied.
Okay.
But my opinion is that the political caucus provision is not good government. See, not good government at all. But
this is an interesting discussion.
I have to give you the right answer under the law.
I know. My father, as you know, used to be the majority leader of the Ulster County Legislature.
I do.
And he tangled, I believe, perhaps even with some reporters and perhaps even with you on this particular topic. Interestingly, his argument would be there has to be a moment when elected officials can get together in a room and hash things out without fear of reprisal and without fear of the public watching, because making sausage is ugly. Do you disagree with that? There's no time at all when there should be a private moment when legislator X and legislator Y can scream at each other.
Well,
without
legislator
the public
X
watching?
and Y can scream at each other to their heart's content. If you have a majority of whatever the entity might be, that makes it very different.
But Bob, you know what they would do then? They would just say, okay, everybody -1, get out of here, and then we'll bring 1 back in. I mean, they would get around the law.
Let me ask you this. Are you familiar with boards of education?
I am.
Yeah, planning boards,
Yep.
zoning boards of appeals.
Sure.
They can't assert the political caucus exemption.
Because they weren't
seem
written
to
into
get,
the law.
because
Interesting.
they're not legislative bodies of those entities that I mentioned before, they seem to get along. They seem to get along. I think what you're really getting at is the ability or the desire or absence thereof for elected officials really to express themselves in full view of the public. That's supposed to be what the open meetings law is about. Now, I'm not supporting the lawsuit. I don't think that they have a leg to stand on. And some aspects of the complaint I thought were almost funny. State senators turning off their phones. Gee, since when does that violate a law?
In my book, it should violate
in your book,
a law.
perhaps, but
that's the thing.
You have a different book.
I do, right? Reporters have always been at odds with elected officials about access. I mean, we are railing all the time about the Cuomo administration not taking our questions, not having enough access, and they say we have plenty of access. It's always the same story.
Well, Liz, you may remember from the olden days, I've said this to reporters 1,000,000 times. There's no law that says that anybody has to talk to you.
Right.
Usually they do because it's in their best interest, and maybe it's the right thing to do in terms of their relationship with the public. But there's nothing that forces them to do so. That's why we have a freedom of information law.
Right, I was just going to ask you about that. The freedom of information law, we haven't seen any tweaks to that in a few years, actually.
Well, we have, but they've been positive tweaks.
Right, but we haven't seen anything significant to dramatically improve it. We had a tweak that said that you had to get legal fees, if not mistaken, when you were challenging the failure of government to provide you with information. But going forward, is it too early yet to know if the Cuomo administration is adhering to the freedom of information laws as we know them?
So far, I have received very few inquiries that relate to the Cuomo administration. Let's put it that way. But I know that Governor Cuomo, as Attorney General, had a good record involving freedom of information. I go back to the days of his father, my first boss, in essence, when he was Secretary of State in 1975.
He's been around.
Yes, I'm old. It's true. And certainly, Mario Cuomo was a proponent of disclosure of access. My hope is that will carry over. I have every reason to believe that will be so.
Okay, but ideologically speaking, do you believe that there are times when the doors should close and that majorities of like-minded or people who share a political affiliation in a conference, the Assembly Democrats, the Assembly Republicans, whoever they may be, the Senate Republicans in this case, should be able to close the doors and hash things out, particularly something as controversial, which really did have political implications, like gay marriage?
I suppose there are situations when it may be in the public interest to permit that to happen. But in general, as we look at the open meetings laws, we look at the freedom of information law. Basically, what they really say is everything is open unless disclosure would hurt. Significantly, either somebody in terms of an invasion of privacy, the government in terms of its ability to do its job on behalf of the public, or, on occasion, a private company vis-a-vis its competition. And I've suggested 1,000 times in public, embarrassment is not one of the grounds for withholding records. It's not one of the grounds for closing a meeting.
Right.
In most instances, I am simply not sympathetic. The law says what it says. It's there for a reason.
Okay, well, as much as I would have liked to be inside some of those 6, 7 marathon conferences that the Senate Republicans had, instead I was in the hallway waiting for them to come out to tell us what was going on. However, in this particular instance, this lawsuit does not appear that it's got a good chance. You said you don't believe it has a leg to stand on.
No, because of that political caucus exemption, which simply removed the gatherings that are at the focus of the lawsuit outside the coverage of the open meetings law.
Okay, and just to be clear, to reiterate for viewers, so people don't get upset, this is not a lawsuit that challenges whether or not gay marriage is appropriate and changing the law is appropriate. It's about process.
That is accurate, in my opinion, and even if this group were to win, I believe that it would be a Pyrrhic victory. Why? Because the state legislature could come back 2 days later and do it right, and it would be the law. It would be the law.
I don't think they relish the idea of taking that vote again.
That is likely so, but I don't think they're going to have to.
Okay, well, we shall see. In the meantime, Bob, it's always fun to talk to you, so thank you very much for coming in.
Thank you.